Start. Bar councils require adequate operational funds to effectively discharge their functions. Stop. They require funds for day-to-day functioning, including administrative expenses, staff salaries, infrastructure maintenance, and technological advancements. Stop. Inadequate funding will hinder the ability of SBCS to comply with their statutory obligations under the Advocates Act. Stop para. The enrollment fee prescribed under section 24(1)(f) was fixed by the legislature in 1993 and has not been modified since. Stop. It fails to account for inflation and is not adequate to meet current financial demands. Stop. Unlike other professional bodies that levy an annual subscription fee on members, SBCS rely on the one-time enrollment fee. Stop. Section 6(2) lays down the functions of the SBCS and places enrollment of advocates exclusively within their domain. Stop. An entity on whom statutory powers or duties have been conferred impliedly possesses incidental powers necessary for its effective exercise. Stop. In view of the above submissions, the BCI has submitted that this court exercise its extraordinary powers under Article 142 to implement a uniform enrollment fee structure that adequately caters to the financial requirements of the SBCS until legislative amendments are made to the Advocates Act. Stop. Additionally, it has urged this court to direct the union government to revise the enrollment fee prescribed in section 24(1)(f). Stop. Other fees charged by the Bar Council of Kerala, such as the sums charged under Rule 40 of Section 4A under Chapter 2 of Part 6 of the Bar Council of India rules cannot be made a condition precedent for enrollment. Stop. Rule 40 of the BCI rules prescribes that the payment be made by an advocate on the rolls of the SBC and thus, it cannot be a prerequisite for enrollment. Stop para. The establishment of the High Courts by letters patent in the presidencies of Calcutta, Bombay, and Madras brought all courts in the territories of British India under a unified system. Stop. The letters patent also allowed the High Courts to enroll advocates, wakils, and attorneys. Stop. The Legal Practitioners Act 1879 empowered the High Courts not established by royal charters to make rules for the qualifications and admission of persons seeking to be advocates of the court. Stop. Initially, barristers and solicitors predominated the original side practice in the High Courts. Stop. Gradually, both advocates and wakils who were Indian non-barristers could act and plead before all High Courts, except for the Calcutta High Court, which excluded wakils from the original side. Stop. The distinction between advocates and wakils led to the demand for the creation of an all India bar stop.